So we're going to talk about some of those legal pitfalls in contracts and especially contract ambiguity. With the recent Star Wars, we discussed that issue and the ambiguity and how that led to the authors not being paid or the writers not being paid, halted payments for inadequate contracts. This also happens in gaming studios. The gaming industry is known for ambiguous terms regarding profit sharing and IP rights that have led to disputes. Developers have found themselves shortchanged due to unclear causes about revenue splits and rights reversion. So this ambiguous language can leave room for interpretation, leading to conflicts over what was originally agreed upon. Also happens in the comic book industry with vague contracts leading to disputes over royalties and rights. Notable cases include creators of popular characters who found that their contracts didn't adequately secure their interests in the face of major adaptations and media expansions. And so, maybe they had their rights to that original character, but then they didn't have any rights to any derivative works. They didn't get any income from any movies that were made or, let's say, marketing that was made, like if it was a Marvel doll or something like that, they didn't get any of that. And that's all outlined in the contract. Maybe they just got paid royalties based on the comic book sales. And so, but now that particular character is huge and drawing in millions and they're getting nothing. There's exploitive contract terms. So those would be contracts that heavily favor one party, typically the large company, often due to a lack of negotiation leverage on the creators, can create unfair conditions. So that happens a lot in your game studios, especially independent developers. They enter into contracts with gaming studios that include unfavorable terms such as really low royalty rates and the complete loss of their IP rights. These contracts, these expletive terms, often arise from power imbalances where small developers have little negotiating power. Again, the small may be many, and so if the many rise, then hopefully you can combat the big evil companies and whatnot that have, they've basically become millionaires off of the backs of these creators, and the creators just get nothing in return. Comic book creators, again, that's another one. They, particularly when dealing with large publishers, creators have sometimes been given minimal compensation for work and later generate significant revenue through merchandise, adaptations, and other media. Again, they create this work and then they don't get to reap the rewards of that work because their IP is stripped from them in these confining, let's say you created a character for like $500, but now they're worth 500 million. That's completely unfair. Your loss of creative control. For example, there are situations where developers with game studios have little to say on how their games are marketed, updated, or adapted. They have no say in what's changed or what's done. I can think specifically, excuse me, Margaret Weiss and Tracy Hickman versus WotC, Dungeons and Dragons, had little to no input on their game book for Forgotten Realms. They just did it anyway and just didn't care. And then they tried to bogart the writers from being able to write in their own world. That was a whole mess as well. You can look into that one. But it also happens with the comic book publishers. They don't explicitly secure the creator's involvement in adaptations or spinoffs where the creators end up sidelined. So you get an instance where, and you see it sometimes, like let's say it's a book, like they're going to adapt a book to a movie and the creator ends up having like no say in the changes that they make to the storyline or the characters. And then it ends up being a crap movie because they destroyed the IP. So lessons learned, the clarity and specificity. I don't I don't know if I said that right. It's a terrible word. Um, the making sure that the contracts are very, very clear and all of the terms are outlined and there are no questions or gray areas. Negotiating fairness, making sure that you are not being taken care of by the big bad company and that you are being paid accordingly for your work, that you are maintaining the rights to your IP, preserving creative control wherever possible. You know, like I said, there is some flexibility. You may have to give up on some of that stuff, but you don't have to give it up. You don't have to give up all of it. You want to try to retain as much as you can. And a legal consultation with an attorney that specializes in intellectual property and entertainment law can help you do that because they're going to know the potential pitfalls and they're going to know what the industry standards are and they're going to be able to read it and say, no, you're not doing that. We're doing this. And they should, if you're paying them, they should be advocating for you. And just making sure that industry standards and advocacy. So, you need to make sure that we have better industry standards and be a part of organizations and unions representing creators who can play a role in promoting the fairness practices and ensuring creators' rights that are protected across various industries. And so I think that that's an important part of be part of the solution. Don't just accept what you're given. If we all stand up together, then the industry will have to change and adapt, or they're going to create everything with AI and it's all going to be garbage. I think that's probably where it's going to go with some companies such as WotC, but we'll see what happens. AI cannot replace a creative mind, no matter what you think. So I think that these legal pitfalls will start to edge out of the industry once enough people step forward and say, hey, I'm not going to let you treat me like this anymore.